morning. Please be seated. We are on the record in cause number CV230550, Schritter versus Schritter. These proceedings are being both video and audio taped, as well as live streamed. So we ask that you please introduce yourself and your client at the beginning of your presentation. We also have a number of young people here who are observing this morning, so for their benefit, if you could do that as well. Each side will have 20 minutes in which to present your argument. You are responsible for reserving any portion of that time for rebuttal should you choose. We have read the briefs in this case, discussed this case in conference this morning. We are familiar with the facts of this case, so bear that in mind during your presentation. At this point, counsel, are you ready?
I am, Your Honor.
Please proceed.
Thank you. Good morning, Your Honors. May it please the Court. My name is Melinda Silk. I'm a sole practitioner with Silk Law Office in Lake Havasu City, Arizona, and I represent the appellant, Lorinda Schritter. We're here today. There's several issues, but some of them kind of commingle in with each other. Our first issue is the court conducting a hearing on a petition to modify in which there was what we believe no material change of circumstances to warrant a hearing. The motion was denied, a hearing was held, mother's parenting time was decreased by 30 days, as evidenced by the child support worksheets that were...
Can we back up for just a second? And on that point, didn't we, the Court of Appeals, say in in re marriage of Dorman that you can't appeal the granting of a hearing?
And Your Honor, it's just part of it. I realize, and I think I put that, or I meant to, if not, that we're not really appealing that. It's just how we got to this point. So it's just a little background information.
Okay, so we simply look at the evidence presented at the hearing.
Correct.
And in this case, the child is now starting school.
So in this case, the parties were divorced in 2018, and at that time, the father lived in Kingman, the mother lived in the Gilbert area, and the trial court gave them equal parenting time because he was not in school yet. So before the child went to school, mother filed a petition to modify because the child would either have to be in Gilbert or in Phoenix to go to school. And there was a hearing held on it. The trial court, which is the same trial court that entered the current orders, took the matter under advisement, and on May 4th of 2020 issued a ruling that set out a very specific parenting time plan. It provided for when the child goes to school.
Again, I'm going back to change circumstances. So the child has now been in school for a couple of years?
Yes.
And the child now has a step brother?
Correct.
Isn't that enough for a change circumstance?
We don't believe so, Your Honor, because
Isn't it pretty much a discretionary call with the trial judge?
It is a discretionary call, but there is a point where you can abuse your discretion. It would be our position that that is a very insignificant change of circumstances. This child was 2, and at the time that the father filed his petition, all he said was he wanted more parenting time, more fun time. He didn't say anything about, oh, now I have another child, and that child is not getting to spend time with the child of the parties. He just said, I want more parenting time to have more fun time, more the holiday breaks, which is what the trial court had already, the same trial court had ordered, knowing the child was going to be in school. So not only did my client not get...
Didn't the child's wishes change also? The child indicated that he wanted to spend more time?
That's what father said. Mother said not. There was
okay,
plenty...
and the trial court made a call and believed dad on that point.
Well, she probably did because she didn't say that she didn't believe mother, but there was substantial evidence that the child was not wanting to go with dad.
Even if there's substantial evidence, don't we just abuse of discretion? We don't reweigh evidence on that point.
Absolutely not. And we're not asking the court to reweigh the evidence. We're asking the court to put some conditions on what is a material change that affects the welfare of the child. The welfare of the child would be something, domestic violence, relocation, something that significantly or materially affects the welfare of the child. it's a product of divorce that parents are not going to get to spend every holiday with their child. They're not going to be able to take that child on every vacation. It's undisputed that father had many vacations with this child, many trips to Disneyland, many cruises, many trips to Utah. And it's the same court that gave him this type of break schedule and even gave him every other weekend in the summertime. So my client didn't even get a whole summer. She would flip-flop, and so father would have every other weekend in the summertime and a week of vacation time. So father had plenty of time, and it's not uncommon for parents of divorced children to celebrate Christmas the next day or when they get them back or a week before. It happens, and that's just the way it is. We don't...
So I'm listening to your argument. I don't think it's unreasonable what you're saying. I'm just saying you presented that bill of goods to the trial court, and she didn't buy it.
And we believe that she abused her discretion because
It's pretty much a discretionary call. And what may be material to one judge may not be as material to another judge.
True.
So,
True.
I mean, how can we in a decision say, oh, you have to do X, Y, and Z? It's just these are factors to consider, and the trial court clearly considered it in this case.
The trial court did, and our position is that she did go beyond the bounds of what is an abuse of discretion, because why even have that you have to have a material change that affects the welfare of the child? Why don't you just say, you know what, you can modify anything, because you can say that under any discretionary matter. And so not only, though, did she change the parenting time, where father said it's only going to be 7-8 days, it was 30. My client only had 130 days of parenting time. She has no criminal history. She has no substance abuse history. She has nothing that would preclude her from having a normal parenting time schedule, living 2 hours away with the extended holidays, the extended summer. Yet she got 130 days for parenting time in May of 2020, and now she's been reduced to 100 days of parenting time.
What if it had only reduced it by 7 days?
Would
that be an abuse of discretion?
No, I don't think at 7 days, but what happened was, and this was...
What number of days is it? That's what makes it difficult for us to say there's an abuse of discretion.
Well, we would still say that having the hearing would be an abuse of discretion, but 7 days could be made up in another manner, in which my client did. My client gave a whole schedule of which father would have the vacations he wanted, but she would get then her time in the summertime, and it was rejected by the court. Now that also goes into the child support issue, because, and I'm going to kind of commingle these things, that father filed his petition to modify parenting time in November of 2022, and he didn't file a petition to modify his...
Did he need to?
I'm sorry?
Did he need to? Under the statute, if you file a petition to modify parenting time, doesn't the statute then require you, if it's granted, to also modify the child support?
I think the statute gives you the discretion to modify it. I think I've had... You're
supposed to consider it.
Yes, you're supposed to consider it.
So the court, at the end of its hearing, had to do a worksheet?
If the court had the proper means to do so, because the court didn't have the proper means to do so.
Okay, a separate issue, but
Yes.
On this issue, the court would have had to done a worksheet, and if the number was a substantial change, it was supposed to enter it, whether or not father filed a petition to modify a child support at all.
Well, we believe in that the court could have considered it back to December 1st of 2023, which would be the month after he filed, and not changed it, because if it had only been 7 days, there wouldn't have been any modification.
Except he had another child, this all goes into the
True.
changes the child support. He has another child, which he claims mother is no longer unemployed, she's now working, so that her income changed.
Correct.
Now, I know she has an issue about father's income, but no matter how you work that child support worksheet, it changed. And so my question is, I'm having trouble with the worksheet because the court backdated it to December, which is the first of the month after the petition to modify
Correct.
parenting time, but the change in parenting time didn't happen for, what was 10 months?
It didn't happen until April 18th of 2023, so it wasn't quite 10 months, about 5
months?
Yeah.
So shouldn't have the court done 2 worksheets?
They should have, and that was our other problem, is that up until that time, Mother did have the 130 days. So we also disagreed with that too. Now, but going back to your question, is that the court should consider child support, doesn't say that the court has to make a modification, and the court has the discretion to say, I don't have the information to change it because nobody brought their financials. Well, Father didn't bring his financials. And so the court could have said, I'm not going to consider it because Father didn't bring his financial information. But the court rewarded Father for not giving his current information and backdated it.
Prior to the hearing, did you bring that to, well, was that brought to the trial court's attention? Was a motion to compel filed? Was any of that done?
No, and the reason is because the court had set, so the hearing was set in February, 9 days before, or let me get the exact date. I don't want to, I won't give you the exact date, but just a week, maybe 9 to 11 days, Father filed his petition to modify, okay? And,
Child support.
To modify child support, yes. And I think it was on this, either it was the 7th, February 7th, February 8th, the court issued the order to appear for the very same day that we were having our hearing. So the court knew that this was going to be heard. And then I was served the next day on February 8th. And we had already been told to do affidavits of financial information. So no, at the hearing, I didn't. My expectation would be that the remedy would be to deny the petition, not reward the petitioner. It would be deny it. You didn't bring it. You didn't follow the rules. You didn't follow the rules of family law procedure. You didn't bring what your income was. Your petition should be denied. And so, yes, I didn't because it was set. The court had set it, and there wasn't enough time even between there to do so. Because I would have had to meet and confer with counsel. And then if counsel didn't do it, then it wouldn't have been enough time because of the time frame in which they filed.
But Father testified about this, and he also submitted an AFI. So the court had information, and when you made your request for the court not to enter a child support modification, the court was, again, within its discretion to deny that?
I don't believe so, Your Honor, because there was clearly income that was out there because Father had a K-1, and Father it's coming from somewhere. So there was tax returns, and Father saying, I just don't have my tax returns. That's not evidence of what his income was. He didn't provide anything for 2023 at all. So I don't believe that if it was in the court's discretion, I don't believe that falls within what the court should do. The court should deny the petition for the failure to, you can file an affidavit of financial information, but what good is it if it's not supported by any evidence of what your income is? And that's the reason you have all your 1099s, your W-2s, your K-1s, your tax returns. They're all required to be there so that you can tie them up with something. And Father didn't have any of it and just came in and said, I just have disability income. And so Father's never provided any income. So we don't have any information to even go back and say, well, this is what it was before. But we did have a K-1, and we know that there is other income out there. May I go on?
Yes.
Okay, thank you. So then we do believe that it was an error for the court to reduce Mother's parenting time, especially 30 days.
I'm still struggling what rule you want us to announce in terms of when it becomes an abuse of discretion. There are some changed circumstances, even if it's just the fact of a new sibling. What do we look to if we're deferring to the trial court? And here you're saying maybe it's okay if it's 7 days, but not 30 days?
I mean, I don't really believe that it is okay, because I think the court could have said, okay, I'm going to give you 7 days here, but I'm going to take 7 days from there, and we're just going to mix it around. Because and going back to, it's not a change in circumstance, it's a change in circumstance that materially affects the welfare of the child.
So you're saying having a new sibling doesn't count?
I don't think a new sibling counts as more superior than mother's parenting time. Because they're saying, oh, they can't go to stepmothers together, they can't.
But hold on, change circumstance only says you're going to have a hearing and the court is now going to review the 403 factors. Change circumstances just gets you a 403 analysis. So once there's changed circumstance, a new sibling, whatever the case may be, then all they're going to do is do a 403 analysis, which the court did here. Pretty thorough one.
But
You may disagree with a lot of it, but it's pretty thorough. And she, at the end of the day, determined that based on her 403 analysis, that this new parenting plan should be adopted.
so there's two things there. It's a change of circumstance, but it has to materially affect the welfare of the child. And a 2-year-old, how does that materially affect the welfare of the child? We're talking a relocation. We're talking substance abuse by a parent. We're talking about domestic violence. We're talking about...
What case do you have that supports that proposition?
And I do
we
have
talk
it.
about an abuse of discretion.
I want to say it's either Backstrand or Black. And I know, Judge McCurdy, you were on Backstrand.
I wrote Baxter.
Yes. So they talk about, these types of actions and not just anything. And so I'm going back to, if you're going to allow just a change of circumstances, you might as well take that clause out that it has to materially affect the child, because anybody then is going to get a modification. But going back to your 403 factors is what I really wanted to address, is that the court did address them, but not really, because the court skipped back to the 2018 decree, didn't talk about anything in the May 4th order, and then came back to this. Father didn't testify about any of the 25403 factors. He didn't talk about any relationships with him and the child other than negative, the child's hitting him. He didn't talk about adjustment to homeschool and community other than the child's getting in trouble at school now. He didn't talk about his parents, his grandparents, wife, sister, brothers, nothing. He didn't talk about any mental or physical health of the individuals, but yet the court did go through those factors, and there was no evidence of any of those. In fact, the only evidence was a recording in which my client used of father's evidence, where the child didn't want to go with father's sister Courtney because she had been spanking him and he was crying and he was scared, and he asked, why isn't my dad here? So yes, there are 403 factors and they're on there, but they're not current. They're not what happened. And in fact, even when we got off the bench, or not off the bench, when the court was ready to leave the bench, she made, and it's in our brief, a very specific declaration to the parties of what she had seen and where they had come from and what they had been doing, and that there might be a little bit of pinch in the parenting plan, but then they have come a long way. And so the court going back to these 25403 factors from not only May 4th of 2020, but 2018, that was not even what was testified in the trial court's hearing that day in February. So we, and I think I have it in my brief, is that the 25403 factors weren't adequately addressed they were addressed by the court, but they don't pertain to what was used in this court. And it was father, so remember, father filed his petition and said he just wanted to be the fun parent, or he didn't want to be just the school parent, he wanted fun time, knowing that he was getting that from the beginning, and then brought up a whole bunch of other things. He brought up the Halloween costume, he brought up the Halloween bags, he brought up Easter, he brought up the long goodbyes. My client didn't have any notice of any of that was even going to be testified to, yet she did have witnesses that were in the waiting room that were able to rebut, who didn't hear any of the testimony, 2 witnesses rebutting what they said. I have about a minute left, so I would like to save that unless there are any questions. Thank you.
Ms. Sandlin.
Good morning, Your Honors, and may it please the Court. My name is Alex Sandlin, and I represent the appellee father in this matter, Tanner Schritter. I believe this case highlights the reason that custody cases are one of the most discretionary ones we see in family court. The courts in custody cases, particularly post-decree, see these families come back through on modification petitions regularly, every couple years in some cases, as we see here. And the court is presented with sometimes similar issues continuing to arise between the parties, and sometimes new issues arising between the parties that it needs to consider in determining, one, whether there's a change in circumstances, and two, what modification is appropriate, if any. Here, the court looked to the change in circumstances, which father in his petition stated that the parties had been implementing the current schedule that was entered in 2020, that actually was an appeal before this court before, and the schedule wasn't working. The child wasn't getting to see his family or father during certain vacations and holidays. Father said that he attempted to speak about this with mother, and mother didn't want to talk about it.
Why is that a change, though? It wasn't that contemplated with the initial order, right? Couldn't you figure out what days, which holidays each parent would have with the child?
I believe the schedule itself was contemplated in the previous order, but parties in co-parenting have to work together, and I think communication is one of the biggest issues that the court has seen between the parties in this case. And so,
Inability to communicate
yes.
and cooperate.
Yes.
But wasn't that true in 2018 and in 2020?
I believe it was, Your Honor, but a continuing inability to communicate can, with other facts, cause a change in circumstances. If the parties, for example, the parties initially had joint legal decision-making with father having final say. A breakdown of communication was part of the reason that father received sole legal decision-making in the 2020 order.
But how does it translate to a 30-day change in parenting time? What are the change circumstances that suggest that it's not an abuse of discretion to say, I'm going to award father 30 more days just because?
You know, I don't know that it was actually a 30-day difference. I know the child support worksheet changed from 130 days to 100 days. However, if you look at the actual modification of the parenting plan in this case, father received 3 additional days of vacation time over the summer. Father received, and you'll find it on page 11 on in the court's order. The regular parenting time schedule did not change whatsoever. The Thanksgiving schedule, prior schedule, was that mother got it every year. The current schedule now is that they alternate years. So that might add a few additional days every other year to father.
And what, in your view, how many days difference is it from what was originally
I
ordered?
believe it was an average of about 12 days different per
Before
year.
we get to the change, though, let's talk about the change in circumstance materially affecting the child. What were those? You said lack of communication, which isn't a change in circumstance, it's a continuing circumstance, you would agree?
It is a continuing circumstance, but I believe it also eventually can create a change. If the parties are continuing to be unable to communicate and reach resolution, at some point the court has to step in and give a resolution to the parties. And so we see the long goodbyes were subject to the previous appeal in front of this court. The long goodbyes have continued to cause animosity and frustration between the parties, to the extent father testified at trial that there was an argument in front of the child at one of the exchanges where the child became very upset. And so that is something that is potentially detrimental to the child and something
But
the
doesn't that
court
resolve differently? I'm still not understanding how that dictates granting more time to one parent or the other. That seems like it dictates saying no long goodbyes. The interactions can be the subject of an order, but why does it dictate, okay, so let's award 12 more days a year to father?
And I think that then goes to one of the other changes in circumstances, which is the fact that father had a new child who is a half-brother to this child. And father's petition and his testimony at trial made clear that the child at issue was asking for more time with father's family during these vacations and holidays.
What's your response to why that should, the question counsel asked, why does that take priority over mother's parenting time? Certainly, the child is already spending more than half the time with step sibling and with father. Why does the fact that there's a new sibling mean mother's parenting time should be reduced?
I don't think it necessarily takes priority, but the court has to look, the paramount question before the court is the best interest of the child. And the court made detailed findings in this case under 403 in determining, hey, this child has a new half-brother. This child has expressed that he wants to spend more time with father and his family. And the court found, I believe it was on page 9, the court found that the court sees value in the child having a full relationship to each parent and in having more than a school schedule in each parent's care. And so after hearing the evidence in this case, the court found that based on the facts between these parties and this child, that it was important for this child to continue spending more time with father and his family over certain vacation times and school breaks. Because that is a meaningful time. You know, Christmas, Thanksgiving, those are special holidays, and spending those with father and his family, the court found and father believed was very important to this child. And so that was within the court's discretion to determine, although time with mother is certainly important, here there needed to be a change to accomplish the child's best interests into the future.
And why couldn't the change be made in such a way as to not deny the overall number of days that mother's receiving? Couldn't there have been an exchange of some days in the summer or something to leave the time roughly?
I believe that could have been an option, Your Honor, but the court in this case considered all of the options that both parties presented and determined that the schedule that it implemented would be in the child's best interest in this case.
Can you talk to us about the timing of the child support modification in relation to the worksheets? Why was there only one, not two worksheets done? Why did the court choose to do it at the petition before the modification took place?
Yes, so there were multiple changes in the child support worksheet from the previous one. One of those were the incomes of the parties had changed.
And on that, to that point, I don't see anywhere in the record where there are tax returns from your client.
Yes, and I don't believe tax returns were presented at trial. Their brief makes a big issue about there being potential disclosure violations. And the problem is the parties went to trial. You know, child support was at issue in this case. While it was not specifically raised in the petition to modify parenting time, the statute is clear that when parenting time is at issue, child support is at issue. Hydebreeder is also clear on this.
Which you would think would have your client giving his AFI and his tax returns immediately because he knows it's at issue.
And I don't believe there's any evidence on when he provided certain documentation on his income. You see in the exhibit worksheet that was filed
Are you saying
with
timing or that he provided it at all?
There are certain documents we can see from the exhibit list in this case were provided. They were from 2020 and 2021, I believe. The disclosure issue that is raised by mother is that there were no 2022 documents. The father testified to this fact at trial and stated that he didn't have tax returns from 2022 yet because he hadn't prepared them yet.
So it's your avowal that there are tax returns from 2021 and 2020 provided
I don't
by
recall
father?
if they are specifically tax returns, but there are tax documents. I believe there are K-1s, there are W-2s, and 1099s. I don't know that they were admitted at trial, but we can see that they were documents that were listed as exhibits for trial. And the issue with mother's argument is that at the end of the day, we went to trial. Mother did not ask for a continuance prior to trial saying, hey, we need more time. I don't have these documents. Mother did not ask to bifurcate and say, okay, let's deal with the custody issues here. Let's have another trial after I've had time to do additional disclosure and discovery and then we can deal with child support. Mother went to trial with the documents that father had provided and then said, well, I didn't get these other documents. There was no motion to compel filed. There was nothing in the court's record up until the date of trial to show that there was any disclosure or discovery dispute that needed to be resolved. While the court can issue appropriate sanctions for lack of disclosure or lack of answering discovery, those weren't requested in this case until we went to trial, until mother's pretrial statement was filed saying, hey, father didn't provide these documents. And that's why we're given these mechanisms to deal with these prior to a hearing, is so we can say, hey, judge, I need these documents, compel the other side to give them. If they don't provide the documents, then sanction them by not allowing a modification of child support.
But isn't that essentially what she requested? The counsel suggesting there was a very short period of time before the hearing, and that the hearing said didn't provide documents, you shouldn't award anything.
Well, and I don't know when the documents father did provide were given to mother. I don't believe that evidence is in the record when they were actually disclosed. On the other documents, again, I think you need to file a motion to compel prior to trial. I don't think you can just go to trial and say, oh, by the way, they didn't give me these documents. That's why we have these discovery sanctions in place that you can request. But when you're just going to trial and saying, hey, I needed more documents, I needed more time, the judge has the discretion to say, why didn't you ask for this before? And father also provided testimony as to why he didn't provide certain documents. And the court, in its order denying the motion to amend, found that petitioner has given cause for such deficiencies, and the court has assessed what weight to give such. And I believe that was in the court's discretion to say, I have father's AFI. Some documents were provided. He provided an explanation as to why these other documents weren't given, and I find that credible.
Let's go back to the question Judge Campbell asked you a few minutes ago, and that is applying the child support order for the first of the month of December with a parenting time of 100 days versus 130 days was error, right? She was having more parenting time than that.
I would agree.
So if the rest of the numbers are correct in that order, in that worksheet, and the corresponding order, it's still error because it is a significant difference.
Well, I would agree that parenting time was not modified until the court's order in, I believe, April. That's not an issue raised before this court today. The issue on child support is that there was a disclosure issue where father didn't provide sufficient documentation of his income, and that the court shouldn't retroactively modify back to December of 2022 because father didn't plead child support in his petition to modify.
I think it's close enough on the retroactivity argument for us to look at it and say, oh, error. So assuming that we do find that there was an error, it isn't to vacate that part and to remand it the appropriate remedy?
I think this court can correct clerical errors on its own. If the court determined that the parenting time
We rarely do our own worksheets.
And this is true. And if the court believes that this is a legal error that needs to be corrected, I think it could remand solely for a correction of the parenting time days between December and the month where the order was entered.
And at that time, we could also order that if there's any, that the court should order the disclosure so that we can really sort this all out.
I don't know that I would agree with that, Your Honor. I think mother needs to show error on the potential lack of disclosure. And mother did not use any...
If we send it back for a redetermination of child support, then she could come forward and say, I didn't get it and I want it, and the rules allow me to have it. Isn't that enough?
I believe it depends on this court's remand. I think this court can do a very small, brief remand of saying, hey, you need to correct the parenting time days in this worksheet. I think the court would need to find that the trial court erred in its modification of child support without those additional documents.
What would your objection be if we were to send it back and mother says, I need these documents, and if father now has tax returns, they're relevant, but would there be an objection to providing the the tax documents?
I think they're certainly, required under disclosure in a petition to modify child support, and that is something that mother can request. And the parties' orders also require disclosure of income information every 24 months. Here, I think it would be the trial court would need to determine, okay, are we going to open back up disclosure and discovery, or am I going to fix the parenting time days in this worksheet? And if mother believes that father's income has changed since then, she needs to file a petition to modify at that juncture. And I did want to touch on the due process issues that were raised briefly. The court has pretty substantial discretion on entering parenting plans that are in a child's best interest. 25-40302 is very clear that the court can enter orders governing the communications between the parties, governing exchanges between the parties. I don't believe this is a notice issue. Parenting time was at issue, and so 25-40302 provides a broad amount of issues that can potentially be raised and that the court needs to consider and enter orders on. Here, the court heard substantial testimony that the long goodbyes were continuing since the previous orders, and that was causing disputes between the parties in front of the child. The court heard testimony that the parties were sending things to the other parent's house without talking to the other parent about it, and it was causing issues there. And so I think...
Could I go back to just whether we could ever find an abuse of discretion when there's change of circumstances? If the court had ordered 2 months additional time for father based on the fact that there's a new brother, a stepbrother, is there ever a point where we say that's not really a change in circumstance that warrants 2 months additional parenting time for one of the parents?
I think it really depends on the court's overall findings. I think in some circumstances, the court could look at it and say, okay, he didn't need 100 or almost all of the parenting time during the year to account for the new sibling. But I think that's why the court is required to make all of those findings under 403, because it shows us its analysis and how it got to this point. And so the court here...
So if it goes through that analysis and ends up only giving mother 30 days of parenting time, is there some point where we could say that's an abuse of discretion, or as long as the court's gone through the analysis?
I think if the findings support that overall result, 30 days would be a pretty substantial reduction in parenting time, but depending on the facts of a particular case, some parents receive 0 parenting time days in an order. I believe it was Gish v. Grayson. One parent got legal decision making and the other got all the parenting time in that case. And so each case, and it's why these cases are so discretionary, we see that the court has to consider all of these factors, and after that consider, okay, what is the parenting plan that is in the child's best interest here? And in this case, the court said, okay, father's going to receive a few more vacation days. Father's going to receive some time over the Thanksgiving break every other year, and then the parties are going to split the fall and spring breaks. And I believe that was within the court's discretion. Unless your honors haven't. Oh, and one final point. The attorney's fees on the motion to amend, I think ARS 25-324 is very clear on that issue. The court considers financial resources and reasonableness of positions. Here, the court, after considering the motion and the response, said, I think mother's just trying to rehash the issues at trial.
Why order a response if it's simply a rehash?
Well, I believe the court can look at a motion and say, okay, maybe there are issues in here that warrant me reconsidering certain evidence. Maybe I didn't look at this properly. And then the response can point out, no, judge, you looked at this perfectly. This order should remain in place. And here that's what happened. By saying that a response shouldn't have been ordered, under the rule, if the court summarily denies a motion, that means it found 0 merit in the motion itself. And here, the motion is largely what they're appealing. And so if there's no merit in their motion, then there's no merit in the issues raised on appeal either. And so finally, my client would ask for attorney's fees on appeal due to the reasonableness in this case.
Thank you, counsel.
Thank you, your honors.
In my last minute, I'm going to try and address several things. First, the first thing council said was cases come back every couple years. That's the whole reason we have this law, is we don't need to have these cases come back and on every single thing. The purpose of the law is to require a material change, and we learned that from Pridgeon. So that we don't inundate the judicial system with everybody coming back after a year. I just wanted to point out the affidavit of financial information was received by father 3 days before the court hearing and had no attachments, which goes also to the request for attorney's fees, because how could the court award attorney's fees, not only because the court found that it was a rehashing, and if that were the case, she should have summarily denied it, but then to order attorney's fees based on ability to pay when they didn't have father's AFI. And the last issue is due process. How would anyone be put on notice that you can't walk your child to the car, you can't talk to the other parent, and find that that is in a child's best interest? Thank you, Your Honors.
Thank you, counsel.
Well, I thank you both for your arguments here today. You've given us a lot to consider. We will take it under advisement. In the back of the courtroom, we have our Chief, Judge Dave Goss, and our, is that you, Judge Bailey? And Judge Bailey, here to talk with the young people here who have been observing us. So welcome. Thank you for your interest in what we do. We appreciate you, and we are now at recess.
And Miss Davis, the young person, that includes you, too.
Thank you very much, Judge McMurdy. I really appreciate that. I'll buy you coffee later.